little slow and moving, but it's doing it.
When you get second, I mean, pass it on this one. You get ready.
Like you're fine, man.
It's upside down, I think. Yeah.
It's been a long day.
Well, it's kind of weird that that's upside down.
Okay, so it typically is the other way, right?
Yeah, typically. Water up here is not a good thing. Go ahead and log in here when we get chance.
Okay.
So this one's on, right? Yes, no, that's fine. You don't even have to put a picture in yeah, I think before is what we use. I was just curious. I never seen one that goes on the picture.
Yeah, he says he wants to. We're going to
Or we in court. But I can do that part of it.
Yeah, it looks like that. Coming up. Right now, I don't know. No, I don't know. You ready? Yeah, I ready. What's up? You want to see that? Right downstairs? The president? Are they? Let us know. Does everybody have their rules correctly? Not to have the judge. Should be one out. Can you sit with me?
Well, we're right about the,
Where are you gonna be?
it is a VGA text, no, you were right. It's just upside down, and I wasn't looking at it. I should know better. I caught this in my hours. So,
No, I work on them all the time.
very good, very good. I'm good, maybe this morning. I'm good. I'm learning from Mr. Lester, trying to, they got it. They got one of them, you can get mine to work. So.
We got 2 meetings down there. Judge Thompson is here and speaking.
So everything, I'm gonna try to meet enable me. First be enabled.
All rise. Come to order. You may be seated.
Judge, what we've done is we've pulled up Facebook, and I just wanted to demonstrate to the court what kind of information is out there and sort of how information is passed along and available to potential jurors, and any pretrial evidence can be discussed. So all we did was type in Justin Ross Harris hot car. And the first thing that pops up, it appears court chatter. It looks as if perhaps there may be a minute-by-minute update on that site. Well, there's all kind of stuff there, as you can see. What I want the court to notice is that you can scroll and scroll and scroll and scroll. Essentially, well, we could probably scroll the rest of the time we're sitting in here in the courtroom this afternoon, and it continued to keep feeding posts to Facebook, and these, of course, are from a variety of sources. They're from individuals. They're from news agencies. They're from bloggers. Of course, it disseminates information, and then it permits public comment. And I would encourage the court to try this very thing. Simply type those 4 words and get an idea of exactly how this information is disseminated and what kind of comments are out there. And I won't take the next couple of hours just to continue to scroll here. This was just an example on one very simple Facebook search, if you will, that I wanted to bring to the court's attention. Take a look at something else. Right, this was Exhibit 13, Judge. And in preparing for this hearing, I just looked yesterday to see what would pop up when I typed in basics. I can't do anything about that, Judge. Here we go.
Class commercialism.
So this is posted yesterday, September the 12th, 2015. It doesn't matter where it comes from. It's on the internet. It's available to anyone who may be surfing online, looking for stories. This could be passed to individuals via any kind of social media site. It could be done through Facebook. But one thing in particular that I want to bring to the court's attention let's see if I can find it. Right. In this article, Judge, if you'll take a look, it discusses public opinion, which is, of course, something that we're obviously talking about here, and I think that the court has got to look at and consider. And if you see the paragraph here, essentially information that the same cousin, I don't know who the writer's talking about here, also has claimed responsibility for sending Ross a video to watch prior to the death of Cooper Harris. The video of an animal dying in a hot car. This is the background that Ross Harris comes from, where watching animals dying falls on the range of normalcy. The public has a tough time with that. Of course, from the probable cause hearing, as well as the warrants which were released, there's no such thing that exists, that certainly that we've been made aware of a video where an animal dies. And I showed that to the court because I just think that's an example of the kind of information that can be out there. You take a little bit of information that's disclosed, and this is what can happen. Well,
Victor Blackwell is joining me now along with
okay. I believe that this is exhibit. I believe this is exhibit 10, Judge. It is. And this is, CNN was posting live updates from the preliminary hearing via Twitter from their reporters. And see if you go through, and this is still online, if you go through, and they're all updating information as the hearing goes along. I bring this to the court's attention to point out the kind of absolute saturation of information that is going on. We get to the point where what's going on in these motions hearings, like a preliminary hearing, it's getting out into the public forum immediately. I want to bring also to the court's attention exhibit number 9. And this was a compilation of HLN live updates, also from the July 3, 2014 probable cause hearing, titled 10 Shocking Revelations in the Hot Car Death Hearing. Now, rather than pull it up because I don't trust myself, I would just ask the court to take a look at that exhibit, and it's the same type of reporting I'm talking about, Judge, where it's sensational in nature based on the information that's being brought forth during the hearing. It's getting out into the public real time, and this information is out there. Analysts and talking heads are commenting on it. But this is how quickly it gets to the public. It's literally got a minute-by-minute update from the probable cause hearing. I want to bring to the court's attention also Exhibit 11. And Judge, that was in an effort, frankly, not to play some pretty shocking videos. I've given the court links to 3 videos that are on the internet. The first one is from YouTube or from HLN, and it discusses some information that came into the public arena via the search warrants. And it's titled Police, Both Parents Researched Hot Car Deaths. The next 2 are available either via HLN site or YouTube. One, Sexting, Just the Tip of the Iceberg. The other, Justin Ross Harris, Online Double Life Revealed. I bring these to the court's attention and ask that you take a look at them because I think it's going to give the court a very good flavor of the type of incredibly sensationalized storytelling that is going on HLN and for all three of these sites anyway. CNN and HLN are everywhere, Judge. Not just in Cobb County and Georgia, but obviously everywhere in the country. These things that appear on these sites and then reproduced and passed around on the internet, it's part of the public domain. And what's happening is we have information evidence, prosecution evidence that is coming out pre-trial. It is then being analyzed, dissected, discussed, and opinions are being offered on it. Opinions are being offered on guilt or innocence, and it's being done in a very dramatic format, to say the least. So I would ask the court to take a look at those as well. Let's see. Mr. Rodriguez, would you mind taking that down here? Judge, I think that gives you a very good idea of the information that's out there. Because it was disclosed in some form of pretrial manner, most notably the probable cause hearing. And I think we've demonstrated the oversaturation, the sensationalism that accompanies this release of information pre-trial, as well as the kind of commentary and discussion that comes with it. And that's where the problem is. I want to ask the court to take a look at Southeastern Newspapers versus the state of Georgia, 265, Georgia 223. This is a 1995 decision. Supreme Court of Georgia concluded in this case, Judge, that closure for pretrial hearings, now it was a death penalty case, but it didn't have near the publicity that this case has. But in that particular case, Judge, there were apparently 2 articles. 2. And based on those two articles, the Supreme Court of Georgia upheld closure. Relying on Lumpkin, the very case that I gave you. And what the court found was that the standard had been met. The court noted that at the pre-trial stage, like we have here, there's less options available. The primary alternative to closure is unavailable at the pre-trial stage. What is that? Sequestration, unless the court wants to hold all motions, strike a jury, and then sequester them before we get started. Justice Hunstein dissents in this case, and I think she makes some very good points. Obviously, I didn't have access to all of the information and argument that was made in this case, but I think she makes some very fair points regarding the burden and the slight evidence that was in that case. She does, however, even in dissent, she reminds us that no right ranks higher than the right of the accused to a fair trial, and that the burden of protecting the accused's right to a fair trial from the prejudicial effect of pretrial publicity falls squarely on the trial courts. My review of these cases that we've cited in our motion, Judge, in some of the cases cited by the lawyers for the media, seem to indicate that the problem with closure for pretrial hearings, or for closure for a variety of matters, is because the trial court did not specifically follow the edicts laid out in Lumpkin. The case that I went over with you when I started, Judge, that is the roadmap. And what I've seen through these cases and taking a look at these Georgia cases is that the trial courts, they weren't following the directives in Lumpkin. One thing in particular that the courts have had a problem with was the failure of the trial court to very specifically consider and lay out why alternatives to closure would work. And so in this case, Judge, I want to go over with you real briefly what those alternatives would be and why they would be problematic. The first thing that the court has got to consider is, like I indicated, you can delay motions until a jury is selected and sequestered. Okay? Well, obviously there's a couple of problems with that. One, we have filed a demurrer and a number of motions challenging the seizure of evidence and statements, the joinder of offenses, constitutionality of statutes. But as I spoke to at the beginning, until you rule on those motions, there are a lot of other motions in limine that are not even ripe yet to be filed. And so that would create a real problem if the court were to hold off all the evidentiary motions where prosecution evidence is discussed until we've already struck a jury and sequestered. Additionally, to bring to the court's attention, we've also filed a motion to sever offenses for improper joinder. Should the court grant that motion, and we've already selected and impaneled a jury, well, obviously, jeopardy would have already attached. We would have already voir dired all potential jurors on the now severed counts, and so it's an unworkable remedy at this stage. Additionally, depending on the outcome of pretrial motions, the parties, the state, as well as the defense, may have certain interlocutory appeal rights. And I will tell the court with all certainty, we do have some motions before the court that if we are not successful, we are absolutely going to make a request for interlocutory review. Those type, and it could very well be situations where the court deems that it really does need to go up. It absolutely needs to go up. And somebody's got to look at this before we go forward with the trial. Well, that's out the window if we've held everything until we've impaneled the jury and then sequestered them. So I would submit to the court that remedy, which is the preferred remedy discussed in Lumpkin, is not appropriate in this case. The second thing the courts require, alternative to closure the courts require to consider, is change in venue. Well, we certainly do that occasionally in larger cases where there has been publicity. But I think as the court has seen and is clear, certainly anybody that has a TV, the publicity in this case is nationwide. We've got CNN, HLN, we've got everywhere. So I don't think that anywhere from Hiawassee to Hayhire that there's going to be any difference in the coverage on those type of cable networks, Judge. So I believe that change of venue is not going to cure the harm which we're concerned with in this motion. The third thing the court needs to consider as an alternative to closure would be postponing the trial. There's no way of knowing what the interest in this case may be 6 months from now or a year from now, but in determining whether or not this is a sufficient remedy, I think the court can just look at the history of the case and see that in the 15 months since he was arrested, public interest does not appear to have waned. If you recall, this case was deemed by the Marietta Daily Journal the story of the year. On the anniversary of Mr. Harris's arrest, both the Atlanta Journal and the Marietta Daily Journal did big one-year update on where the case is. And I would suggest to the court that intentionally delaying this trial for the sole purpose of seeing if public interest or media interest will wane is not reasonable, and certainly doesn't serve the interest of justice for either party. The fourth matter that the court should consider in determining whether it would be a sufficient alternative to closure would be a gag order on the press and public. This isn't addressed specifically in Lumpkin, but it is in some other cases. And certainly gag orders are something that courts do occasionally, rarely. I think what we've shown the court through the evidence today is that would not be a sufficient remedy to ameliorate the problems of pretrial publicity and the disclosure that we discussed. I mean, let's assume that the court issues a gag order on the press, and I'm sure counsel will have a lot. They would argue substantially about that. But let's say that happened. Well, if we have an open courtroom is an open courtroom, and so that means anybody can walk in and out of here, as they should be able to. Walk in and out of here, listen to the evidence, go right back out in the hallway, and put that information on their cell phone, get it on Facebook, and it's passed around. And that's why we showed you the Facebook link, so you can see that that's exactly what would happen. You can't, if it's going to be an open courtroom judge, you can't gag the people coming in and out. That would be an unworkable situation, and obviously it would not cure the harm that we brought to the court. Another matter that the court should consider as an alternative to closure is a searching voir dire. I believe one of the lawyers for the media suggested that this may be a more appropriate measure than closing the courtroom, and certainly we don't disagree that a very searching voir dire we don't suggest that's not appropriate. I think it's pretty clear that's going to happen in this case. We're going to have an opportunity to question jurors. And it's a good tool to determine to what extent they've had exposure to pretrial publicity, and to what extent they may have some fixed opinion about the case or about any particular piece of evidence. However, our position is that this is a unique and rare instance. There is a clear and present danger that without strong court measures here, curtailing the pretrial information into the public forum, there's not going to be the right to a fair trial. And I mean, if that's the case, Judge, essentially, I think the court would be saying, well, yeah, there may be clear and convincing evidence that there is such a danger, but what we're going to do here is we're just going to kind of wait and see how it goes. We'll let that harm occur, and then let's hope for the best. Let's hope for the best when we try to select a jury. I don't think that Band-Aid approach is appropriate under these circumstances. And I don't think that would cure the harm that we're concerned with. All right, the final measure that court should consider as an alternative to closure are jury instructions. Well, I have no doubt that when the time comes, this court is going to give very thorough jury instructions, which will very likely include a very specific instruction that the jurors are to consider only evidence that came in the courtroom. That's not uncommon. But again, we've got the problem of that's really trying to unring a bell. If we've had juror exposure to matters which, again, like I said at the beginning, Judge, very well could be excluded on a number of grounds, suppressed on a number of grounds, limited, redacted. Do we knowingly allow that to come in and then try to unring the bell with a jury instruction? In our position, Judge, is that is just not reliant upon jury instructions in these circumstances to unring the bell and to jealously guard Mr. Harris's constitutional right to a fair trial. It's just completely insufficient. I have looked at the, and in a nutshell, Judge, that's what you need to consider. That's what we're asking you to consider, those alternatives. And we believe that they're ineffective, but the court in Lumpkin has indicated that those have to be very specifically laid out. I have a proposed order for the court. Look before I hand it to the court. I'm going to read what specifically that we're suggesting would be appropriate. I'm asking the court to find that, to grant our motion for limited closure with these very, very specific limitations. That the defendant shall notify the court of any suppression or constitutional motion or motion in limine in which it is expected that prosecution evidence will be disclosed and discussed. There are some motions, Judge, but that's not going to be the case. In particular, there are some constitutional motions to mirror and whatnot that we don't think it's going to be necessary to discuss potential trial evidence. The court will reserve the right to require a defendant to make an ex parte proffer of what prosecution evidence he expects to be disclosed or discussed in any particular pretrial hearing. In other words, the court can call a bull. The court can call a bull if we say, Judge, this needs to be closed because we think it should be closed. I think the court should have the right to bring us in chamber and say, all right, well, tell me exactly what evidence you're talking about. I think that kind of safeguard would be a particularly effective measure to make sure that there is that closure is very limited and very narrowly tailored to effectuate, to ameliorate the harm that we're trying to do with this motion, Judge. For such pretrial matters, the courtroom will be closed to all individuals except the parties and counsel and the central courtroom personnel, sheriff's deputies, clerks, and so forth. The hearings will be reported and transcribed. The cases speak directly to that, Judge. I know that counsel's going to get up here and suggest, well, we just don't do closure. We just don't do it. Well, the fact is that even the cases where closure was found inappropriate or not warranted, all of those cases recognize that closure does occur and is appropriate in limited circumstances. And each of those cases discuss how to limit any harm to the press and public. And one such way is that, hey, we're going to record and transcribe the motions. The parties nor the courtroom personnel will disclose or comment upon the evidence, argument, or court ruling during the closed hearing. The court will determine whether a written order on any pretrial motion shall be filed under seal until a verdict is reached. And I think that's a particular safeguard that the court obviously should have. Transcripts of any closed proceedings will be filed with the clerk of court and otherwise made available within a reasonable time following a verdict. All other hearings not otherwise specified herein, along with jury selection and trial, shall be open. That's what we're asking the court to do. I have had an opportunity to take a look at the responses from the lawyers for media, and I don't know that we really disagree with what the standard is, Judge. The media lawyers suggest perhaps some of the cases I cite have been distinguished. They're all good law. I haven't cited anything that's not good law. And so I think you can rely on the law that all of us have given. It's all going to come down to whether the standards in the Lumpkin case have been met. The motion filed by Mr. Bauer, I would take issue with the suggestion that somehow the publicity is my fault because I filed pretrial motions, and that I have apparently acted as a puppet master and manipulated the media to our ends and then seek closure. I think that's unfair. I think it's inaccurate. I certainly have the right to make public comment when it's necessary to protect my client's rights from unfair pretrial publicity, and I've not been out there doing that. And so I think that's unfair. And more importantly, I think that's beside the point of what the court has to consider when applying the information that we've given you here today about the publicity and apply it to the standards in Lumpkin and the other cases. So that's our motion, Judge.
Proceed with the step.
Your Honor, as I'm sure we've been going for a while here, you don't want to have the standards read over and over again. I believe the media attorneys are going to cover that quite in depth, so I would defer and let them argue first, if that's okay with Your Honor, and save my comments until after they've addressed the legal standards they're opposing.
I'm sure they're not going to mind doing that.
I didn't think so.
Which gentleman cares to go first?
Your Honor, with your permission, I'll go first. Very good.
As long as y'all are that in.
No problem. Good morning, Your Honor. Again, I'm Tom Clyde. I'm here on behalf of the Atlanta Journal-Constitution and WSB-TV and WSB Radio and the Associated Press and CNN. I very much agree with defense counsel that the Page Court versus Lumpkin decision is a roadmap towards directing the court as to the standards that have to be evaluated in this case. I think where we disagree is where that roadmap ends. The court in Lumpkin made very clear that in the state of Georgia, open courtrooms, including pretrial hearings, is one of the cornerstones of our judicial system. As the court announced in that case, they said they believed that open courtrooms are the sine qua non of an effective and respected judicial system, which in turn is one of the principal cornerstones of a free society. The court went on to explain that because of the constitutional mandate in our state constitution that criminal trials shall be public, a trial court judge in Georgia has less discretion than a federal court judge would have in order to close pretrial proceedings. Really, three things came out of the Lumpkin decision. The first is essentially this issue that the trial judges in this state have less discretion. And I'm going to quote from the opinion because I think it shows how much emphasis the court puts on this issue. A Georgia trial court must approach these issues possessed of less discretion than his federal counterpart because our Constitution commands that open hearings are the nearly absolute rule and closed hearings are the very rarest exceptions. The other principle that came out is the standard that was articulated by Mr. Kilgore, and that is hearings shall be open to the press and the public on equal terms unless the defendant or other movement is able to demonstrate on the record by clear and convincing proof that closing the hearing to the press and the public is the only means by which a clear and present danger to his right to a fair trial can be avoided. So it has to be clear and convincing evidence, and it has to be a clear and present danger. It clearly involves a profound evidentiary showing to the court. And finally, as Mr. Kilgore indicated, the court requires that the trial judge not just consider, and that would be the standard at the federal level, but implement alternatives to try and remedy the potential prejudice. And so that includes change of venue, postponement of the hearing until after jury sequestration, searching voir dire, emphatic instructions to the jurors. So each of those are essentially a precondition to closing the courtroom. So where do we stand in this case based on that roadmap? As a threshold matter, there really hasn't been a showing of prejudice that is sufficient to meet the standard to even for this court to take the step of considering the alternatives to closure. And why is that the case? Essentially, the defendant has introduced a large number of newspaper articles that are posted online and published in a print edition. He's introduced synopses of television reporting and a number of links to CNN reporting, to HLN, other reporting. But as a basic matter, if the court goes through that, that reporting basically sets forth the procedural steps that have taken place in this case. The showing that's been made to date is basically trying to pick a few sentences out of those articles and try and suggest that they create a great sense of prejudice. Those sentences, when they're looked at in the context of the article, don't create that impression, especially when you look at the sequence of reporting. A lot of the comments that Mr. Kilgore focused on were initial comments made in the aftermath of the death of the child in this matter. And if the court recalls, essentially in that situation, this was initially thought to just purely be a tragedy, a tragic accident. And then slowly it became apparent that the state of Georgia, through the Cobb County District Attorney's Office, thought that there might be significantly more going on. And ultimately, the state of Georgia took the position that this was premeditated murder of an infant, of a toddler. And that's where we stand today. Is that a shocking development? It is a shocking development. It was reflected as a shocking development in a case that was initially simply seen as a tragedy. But there's a difference between an unusual turn of events and prejudice. that unusual turn of events was accurately reported on the media. It also resulted in people expressing their opinions and commentary, but that is not prejudice. That is essentially a volume, a significant volume of reporting, but our Supreme Court has emphasized in the aftermath of the Page versus Lumpkin decision that that's not the inquiry. The inquiry is not the volume of reporting. Criminal trials, especially ones that arise out of unusual circumstances, will create a significant volume of reporting. But what the court says has to be the judge is prejudice. Prejudice that rises to the level of a clear and present danger to the trial. And that simply hasn't been shown in this case. The defendant has emphasized and provided to the court a copy of the Southeastern newspaper's case. That decision was issued by our Supreme Court now 20 years ago in 1995. It was candidly, immediately the subject of a significant amount of criticism in that year. The Supreme Court immediately took another pretrial publicity case, the Rockdale Publishing decision, and issued another decision in that year and explained in detail the standards that have to be met, reiterated its emphasis of Lumpkin, and reversed a trial court that had approved the closure of pretrial proceedings. In the Rockdale decision, the Georgia Supreme Court emphasized these words: pretrial publicity, even pervasive adverse publicity does not inevitably lead to a fair trial. What has to be shown is prejudice. The court also emphasized that under our system, you're not entitled to a jury that knows nothing about your case. That's never been our system of justice. What you're entitled to is a jury that can put aside the knowledge it has and evaluate the case based on the evidence that's been presented. When you look at the records that have been submitted to the court, there is nothing so profoundly prejudicial in this case that could support a clear and present danger standard. But there's also another significant problem with the evidence, and that is the defendant is essentially focusing on past reporting that is already in the public domain as a result of the probable cause hearing that took place in that case. That information is going to remain in the public domain. The real focus of this hearing today should be on what is the potential, the supposed evidence in the upcoming hearing that supports the idea that somehow it could rise to the level of and support showing that there is a clear and present danger to the defendant's right to a fair trial. There's been no showing at all, literally no showing at all this morning about what it is in these future hearings that could potentially create this and meet this standard. Essentially, defense counsel, as best as I can tell, I haven't seen his proposed order, but from how he's describing it, is saying the court should just enter a sweeping closure order now, and then in the future there should be ex parte hearings in which the court evaluates whether to close a particular hearing in the future. Essentially, Your Honor, I think that reflects the showing today really hasn't been made to support any kind of closure, but it also, that request has the procedure wrong. The Lumpkin decision makes quite clear how this is supposed to work. If the defendant has at some time a feeling that upcoming testimony, upcoming evidence in a hearing is sufficient to meet the Lumpkin standard, then he should bring the motion to close, and if there's information that he wants to share with the court that if it was disclosed would undermine the very reasons for closure, then he can go in chambers with counsel for the media, and we would examine that allegation in that context. In footnote 10 of the Lumpkin decision, it sets out that process. But that Instead, essentially what's being proposed today is that the court should sort of enter a generic, sweeping motion to seal future court hearings and then on an ongoing basis evaluate it without media counsel being present. And I would submit that not only shows a showing hasn't been made today, that's quite contrary to the footnote that's set forth in Page versus Lumpkin about how this is supposed to go forward. Your Honor, during this issue that a showing really hasn't been made today was demonstrated when Mr. Kilgore essentially described that his suppression motion could include prosecution evidence that would be damaging to his client. That future in limine motions could include such information, that the court could redact recordings or statements, that there might be evidence that the court his motions could include evidence that the court would ultimately deem not relevant for purposes of trial. That is all speculation. Speculation is classically insufficient to close a courtroom, and the Georgia Supreme Court has said that many times. There would have to be some kind of concrete showing that rose to the level of a clear and present danger, and that simply hasn't occurred. What has occurred is essentially a presentation of straightforward news reporting that's included in the exhibits that have been submitted to the court, and then a presentation on the fact that in the modern system, news reporting takes place on a real-time basis. That's not an unusual development. Obviously, electronic media and the creation of the internet has allowed the media to deliver news information on a much faster basis. That news information sometimes leads to individuals in social media to express their opinions, to make speculation, but that has never been a basis to seal courtrooms, and in fact would be counterproductive. In other words, if this court were to seal courtrooms in the future, all that's going to do is lead to a great deal of speculation, a great deal of rumor on social media about what's being discussed in the courtroom. What are the issues that are being evaluated in the courtroom? In contrast to that, if the courtroom is kept open, then essentially straightforward news reports come out of that reporting, and the media and the public finds out about the way the judicial process operates in this system. That is essentially what the Lumpkin decision was encouraging. Your Honor, I want to turn also essentially to something that is a present here that is one of the major distinguishing features from the Southeastern newspaper case that's been given to the court. Cobb County is one of the most populous counties in the state of Georgia. It has a population of over 700,000 people. The authority the defendant is primarily relying on, the Southeastern newspaper case from 1995, involves Liberty County. At that point, the population in Liberty County was less than 60,000. And that is essentially what ultimately led to the Supreme Court quickly taking another case, the Rockdale Publishing case, and demonstrating that this is not open season on closure. Here, there is an enormous jury pool available to the court to pick a jury that is capable of rendering a verdict in a fair and even-handed fashion. And the truth is, in the metropolitan counties, and the counties around metropolitan Atlanta, which all have significant populations, there has never been closure of pretrial proceedings prior to a high-profile major trial since the Southeastern newspaper's case. And Mr. Kilgore said that this is a unique and rare situation. I would certainly agree that this is a high-profile matter, but it is not unique and rare. There have been many, many high-profile cases handled by the courts in the metropolitan Atlanta area in an open and public way. In DeKalb County, the trial of Sidney Dorsey after the assassination of Derwin Brown was an extraordinarily high-profile criminal proceeding, and it took place in a completely open way. There was no closure of pretrial hearings. In Fulton County, the trial of Brian Nichols for the courthouse shooting was again a case with enormous public attention. I would submit to you that both the Sidney Dorsey case and Nichols case were significantly higher profile cases than this. Again, there was no closure of pretrial proceedings. The courts rejected those motions. Cobb County has had its fair share of high-profile cases. The Lynn Turner case over antifreeze murders was a very high-profile cases. In all of these cases, changes of venue got considered. In some of them, changes of venue were pursued, but in none of them was pretrial hearings closed to the public, and that is consistent with Lumpkin. The change of venue has to be a remedy used prior to closing pretrial proceedings. Even in the social media environment, there's continued to be high-profile cases that are handled without the closure of pretrial proceedings. The Snyderman case, really two cases involving the Snyderman just took place in DeKalb County. There's also been a recent prosecution in DeKalb County of that county's former CEO. Again, no closure of pretrial proceedings. The fact that social media exists hasn't changed the standard and hasn't changed the ability of the court to properly seat a jury and handle these issues with a searching voir dire, strong instructions. So, Your Honor, we would submit that the two important steps that are defined by the Page versus Lumpkin decision have not been met in this case. First of all, there hasn't been a showing sufficient to meet the clear and convincing standard. I would submit that the idea that the defendant should be allowed to make some kind of ex parte proffer in the future is a concession that they haven't made the showing today that is required to seal hearings. And what's also clear is that it's not really at this point even clear what hearings the defendant is asking to close. A great deal of the hearings that are currently before the court involve essentially challenges to some of the charges arising from alleged sexting in connection with the right of privacy. That is essentially a debate about constitutional issues and the reach of our constitutional right of privacy and the charges that are lodged against it. That is classically a discussion that can take place in open court. The motion to sever charges is again also an issue about how connected these charges are. Those are hearings that should take place in open court. With respect to the other motions, there's been no articulation anywhere of what it is that creates the clear and present danger. So we would submit that they haven't met the extremely demanding standard articulated in Lumpkin. And then they haven't, because we don't really even know what hearings the defendant is seeking to close, then it's impossible to evaluate, even if we were to reach that point, it's impossible to evaluate whether alternatives are available. A sweeping closure motion over undefined future hearings makes it impossible to really evaluate that standard in any serious way. I would submit that in truth, it's clear that a change of venue in this case, I think the court will be able to see a jury in this county because of its significant population. But a change of venue would certainly remedy, if there was a problem, would certainly remedy the issue just as it did in other cases in the past, just as it did in the Lynn Turner case. And that is a step that the court's required to take before it closes pretrial proceedings. Your Honor, finally, I'd just like to emphasize much of the information that the defendant has focused on today is information that came out in the probable cause hearing. That information is out in the public record. It will remain in the public record. Sealing cases, sealing hearings in the future is not going to make that information go away. Sealing hearings in the future is simply going to create a great deal of uninformed speculation based on that information about what's occurring in the courtroom. This courtroom showing how it handles the allegations in this case, how our justice system decides what is sufficiently probative to be included in the evidence at trial, demonstrates to the public how we operate in an open and public fashion and how we sift the evidence in this case in order to put the state to its burden of proving its case beyond a reasonable doubt. I would submit that sealing the courtroom is simply going to be counterproductive to trying to put this case in the best possible position to be tried on a reasonable schedule. Thank you, Your Honor.
I think what we need to do is break until 1:30.
Your Honor, I only need 5 minutes.
We have 5 minutes, that's it.
Thank you. Given Mr. Clyde's excellent presentation, what he said largely would like to be adopted by WXIA.
No, why don't you just say that?
No objection.
I hope I just did. I do want to make 3 quick points.
Yes.
First, with respect to Mr. Kilgore's comment regarding an issue raised in our briefing for WXI and WGCL, the issue isn't that Mr. Kilgore's, it's his fault that this case has such a high profile or has attracted such publicity, and that's not what our brief was intended to suggest. But it was ironic that Mr. Kilgore did put up on the video a Facebook feed to show the court how prolific social media has been, but he scrolled past the very first entry on that page, which was a shared article about this case, and in fact about this hearing, by Lawrence Zimmerman, who's the attorney for the defendant's wife. And the point is that both the defendant, through his counsel, who at one point, I understand after the probable cause hearing, invited AJC attorneys to review case files in order to generate news articles to combat some of the information that was unfavorable after the probable cause hearing that was being reported on. There has been a clear effort by the defendant and his counsel to participate in shaping public opinion about the case. And as Mr. Kilgore correctly said, that is entirely within his right to do so. But as a matter of public policy, given the legal standards that Mr. Clyde so eloquently laid out for the court, it would be a terrible rule indeed if a defendant could make affirmative use of the media to shape public opinion about his case and then claim that that very media attention to the case is a basis from which to preclude the public from further access to key pretrial proceedings. He talked about these pretrial motions, and as Mr. Clyde referenced, none of the motions that actually could arguably present a clear and present danger have actually been identified, and all the motions that are on file have been public and on file for a year. And the defendant's counsel pointed to no media reporting about those motions that could suggest that anything prejudicial has been reported because of those motions' presence on the docket. Notably, he omitted all the favorable reporting that has been elicited by defense counsel's efforts or by efforts of the defendant's family and friends over the last year in his recitation of the harm. But primarily I want to take issue with 2 things. Number 1, the quantum of evidence. Mr. Clyde said that there's been no presentation rising to a clear and convincing standard of proof, that there's been a clear and present danger. There are mechanisms that were available to the defendant to make such a showing if he cared to do so. He could have surveyed the jury pool in Cobb County, he could have surveyed beyond the county borders and presented information to actually demonstrate a clear and present danger. Instead, he's asking you to assume that it exists. And the law doesn't permit that kind of assumption in this kind of case. And then second, the suggestion that this is really a rare and unique case. Mr. Clyde gave you some local examples. We cited in our brief the Timothy McVeigh case, which is frequently cited by courts around the country for the proposition that you can very effectively, even in the highest profile case, with the most pervasive media attention, when everyone can fairly say that the media's reporting had been highly negative with respect to the defendant's potential defenses to be raised at trial, even in those types of cases, which has captured the interest not just of Cobb County or Georgia or the nation, but the world, searching voir dire and strong and clear instructions by this court are the appropriate remedies. And I did not hear Mr. Kilgore articulate any reason, any sincere reason why those remedies could not be appropriate. For that reason and for the reasons articulated by Mr. Clyde, my clients WXIA and WGCL would ask the court to deny the motion. Thank you.
We are going to recess until 1:30. Everyone have a good lunch.